GRMANN, bar number 126353.
And Ms. Loeb?
And good morning, Your Honor. Madeline Loeb, spelled L-O-E-B, bar number 173970.
All right, Ms. Weinmiller?
Morning, Your Honor. Chris Weinmiller for Ms. Brophy. Weinmiller is W-I-N-E-M-I-L-L-E-R, and my bar number is 863177.
Good morning, Your Honor. Lisa Maxwell here with Ms. Brophy as well. My bar number is 844337, and my last name is spelled M-A-X-F-I-E-L-D.
All right, give me just one moment. Before I rule on some of the things that were discussed yesterday, I'm realizing that the one thing I did not look at was what has been marked as Defense Exhibit 403, which was the plea petition. So I will have to give a ruling on that particular document a little bit later today, but can you remind me, Ms. Maxfield, your argument on that one?
Your Honor, I don't think it was the plea petition. I think it was the plea agreement.
Okay, sorry.
Yeah, and the reason we want to offer the plea agreement is that it sets out basically the analysis for a fraud offense. And Ms. Jacobs had testified that she had no idea how a fraud might play out, but in fact, this very specifically sets out how the fraud guidelines work, providing her with a basis of knowledge. And I think that the letter ends with her having to sign that, saying that she read it and understood it. Is that correct?
That is correct, and one of the things we wanted to address with the court before the jury comes in addition to hearing the court's ruling about this, is how that impacts specific exhibits, which of these we can use with the witnesses. There are some that we understand we'll have to proffer and just have in the record with the court and not use with the jury, but that's a particularly important document and one that we would want both to use with our first witness and to have admitted.
With the first witness?
Yes,
Who's the
Donna
first?
Maddox.
Oh. And I apologize to the state too. I can't remember what the state's viewpoint was of defendant exhibit. We are talking about exhibit 403, is this correct?
Yes, that's the second
right.
superseding plea offer. And we, on our list, we actually entered that twice as 430, but 403 is the one that's been provisionally admitted for purposes of the hearing, and that's the one we intend to use.
All right, and the state's position on 403?
Yeah, what the defense is asking is to connect the dots without there being any way to actually do that. Because what they're suggesting is that Ms. Jacobs, one, even knew what she was potentially being charged with, which she didn't appear to know, and also, again, pointing out that the DOJ had not made that decision. So even if she recalled this document that she signed a couple of years ago, and understood all of its contents today, or at the time that she received that DOJ letter, one, there's no evidence that she had contemplated that or even considered this prior plea petition once she received that letter. And then furthermore, even if she did, she doesn't know what she's being charged with. So how could she possibly know what her sentencing exposure would be, even with knowledge of this document?
All right, and let me ask, all right, and actually, on a totally separate matter, I'm going to ask, what's that? I'm sorry? Okay. I'm going to ask, it doesn't have to be the entire defense team, but I'd like to have one attorney for the defense, at least one. You can both come if you want, and one attorney for the state. You can all come if you want, but this is not, it's not a legal issue. It's sort of a logistics issue. But I would like to talk in the hallway for just one moment. So let's go off the record. Please be seated. And we are now back on the record. As always, I will give an explanation for my rulings, but let me go through what I think we discussed yesterday. With regard to Ms. Rosalind Lee's testimony, I am sustaining the objection to her testimony. The evidence is that Ms. Jacobs never reached out to law enforcement seeking consideration in exchange for testimony against Ms. Brophy. To the contrary, detectives had to figure out who she even was via the interviewing of a separate witness. During their interview, Detective Merrill did indicate that her testimony might have value, but he didn't make any promises about what that would entail. Ms. Jacobs repeatedly said during the interview that she had not wanted to be a witness in the case and did not want to be a witness now, assertions that she repeated while she was on the stand. She testified that she was getting nothing for her testimony and that testifying could be dangerous for her since she is still in custody. The scope and strength of her testimony was less than what she had told detectives on April 28th, which supports her contention that she wasn't attempting to assist the prosecution. Ms. Jacobs testified that she had recently learned about the investigation into the Medicaid fraud, but that her testimony in court in the present case was unrelated to a hope of consideration for that case. Now, in reviewing this, I of course did look at State v. Houston. I also looked at Kirkpatrick on evidence and the commentary section with regards to ORE 609-1. And it gives 11 examples of possible forms of bias. The 11th they provide is an agreement to grant immunity, recommend leniency, drop another charge, or any other concession by a prosecutor or law enforcement officer to a witness in exchange for their testimony. Other than Detective Merrill's comment about Ms. Jacobs' testimony potentially having value, there simply is no evidence that any of that exists. Now, mindful of the fact that impeachment should allow wide leeway, or that the court should allow wide leeway for impeachment, the court has allowed defense to cross-examine the witnesses about a pending criminal investigation, which I reiterate, she is currently presumed to be innocent of. Defense was allowed to ask about a 2-year time frame for which the alleged conduct occurred, as well as the specific dollar amount that she's alleged to have defrauded. Now, the testimony of Ms. Lee is entirely speculative as to what Ms. Jacobs knows about her potential exposure for a case that isn't even charged. She does not know Ms. Jacobs personally and has never communicated with her. And while she can generally speak to her practice in discussions she would have with her clients about exposure in the investigation stage, she simply has no idea what Ms. Jacobs has discussed with her attorney in that investigation. In addition, given that Ms. Jacobs only learned about the investigation a few weeks ago, we don't know if there's been any conversation about potential exposure at this point. I simply don't read State versus Houston as broadly as defense does to suggest that this would be an appropriate form of extrinsic evidence. And along those lines, I had a chance to, I had read 403 before, but I hadn't recently. I'm also going to sustain objections to introduction of 402 and 403, excuse me, as being admitted. In 403 specifically discusses, which I've already ruled cannot occur, some of the particular acts that were committed that led to the conviction for which Ms. Jacobs received. Now, on another note, I'm also sustaining the objection to the state's admission of Exhibit 116. I believe it to be a very minimal probative value to the extent Mrs. Brophy referred to Ms. Perez as a Hispanic girl or Mexican girl, and I don't remember the exact phrasing. I believe that the danger of unfair prejudice, that the jury would focus on that phrase if they repeatedly played the voicemail, would substantially outweigh any minor probative value of the voicemail. They've already heard it. What she said is in evidence, and the state can certainly argue that it has whatever meaning they believe it has. Did I miss any exhibits? Those were the, I'll ask defense. So I just talked about 403 or 402. Were there any other that I missed from yesterday?
Um, Not that there was dispute about, but I think it probably would be helpful before the jury comes in to go through some of the other exhibits that we would propose be admitted or at least used with the witnesses.
Sure.
Before.
And before we get to that, though, I do want to also ask, just sort of planning out today, I should tell the parties, I have to break a little early for lunch today at 11:45. So that's just a logistic matter. But I received an email this morning, or maybe Ms. Lou received an email and forwarded it to me about the defense witnesses for today, or proposed witnesses. It included a few new names, which we didn't discuss yesterday. Just so I'm clear, Patrick McCarthy is the urologist?
He
Is
is,
that
he's the
correct?
victim in the first case, that 2018 federal case.
Okay, and I understand the state may object to his appearance via WebEx in the same fashion they did witnesses yesterday.
Yes, but that is our only objection.
Okay. The only thing I would ask, have you had a chance, Ms. Weinmiller, to discuss with him the parameters of his testimony? What he can
We
talk?
plan to do that over the lunch hour. He
Okay.
was just subpoenaed last night. He and his wife apparently both have COVID, and
Oh,
so it was
okay.
been very difficult to communicate, but we would do that before calling him.
Okay. And then the other additional witness was Ms. Hersher. Um, Well, I guess I'll first ask, does the state have an objection to Ms. Hersher?
Yes.
All right, then I'll ask the defense, what would she rebut with regard to Ms. Jacobs?
I think that what well, her testimony would be that, well, the court's familiar with most of her testimony. Her testimony would
Right.
be that right about the time that Ms. Jacobs was incarcerated with Ms. Brophy, that Mr. Overstreet reached out to her to find out whether her client might be willing to offer information against Ms. Brophy. And I think that the time frame for that would be February of 2021. That she then went to visit with her client, who she describes as, quote, a hothead, to pass on what Mr. Overstreet had said, that she was worried that her client was going to fire her, and that her client was furious after she had passed on the information, and she was instructed to then call me and let me know that her client wouldn't be offering any evidence against my client. The fear at that time, though, was that her client would have shared with everybody within that tier that Mr. Overstreet was looking for an informant. So I think that what it would rebut is whether, in fact, this witness didn't have a hope of currying favor with the prosecution based on that knowledge that went through Inverness early on, as early as February of 2021, and that her subsequent statements to police were consistent with her knowledge that there would be a benefit that would follow.
All right, does the state want to respond?
Several things I'd like to say, Your Honor. First of all, given the fact that that recitation of facts is simply not true, that causes a big problem for the facts that the jury may hear. I'll remind the sides that Alicia Hersher testified in a motion to disclose attempts to locate a cooperator. I believe this court, I think, I don't, correct me if I'm wrong, Your Honor, but after my proffer, concluded that the state had not gone into the jails to find cooperating witnesses.
I don't think that's what Ms. Maxfield was saying. I think the way I interpreted what Ms. Maxfield was saying, I'll let her correct me if I'm wrong, was that by virtue of Ms. Hersher's conversation with her client, word got out around the February timeframe in the jail, or possibly got out that the state was looking. I think
Sure.
that's what she's arguing. Not that the state was going in there trying to find anyone.
Right, I'm just providing context for why Ms. Hersher was testifying last time.
Mhm.
That was the context.
Oh, sure, okay, I understand.
That, and so the context was a little bit different. I understand what they're saying now, because they were alleging that we had reached out to law enforcement partners and were trying to find witnesses. We, of course, reported back to the court that we checked with all our law enforcement partners. That never happened. We never did anything like that. So that's just the context for a prior testimony. But what they're attempting to get it in for now, one, I believe is outside the scope of your order, but it also doesn't actually relate to any of the state's evidence that we put on. It's not relevant, and it's also complete hearsay. So that's the basis of all my objections. But the reality is what they're asking the court to do again is allow not inferences, but complete speculation that information was shared. And by Ms. Hersher saying that we reached out to her, one, we would need to rebut that because it's not true. And I believe that would only come through the form of my testimony.
Right.
And that was then relayed to her client, and that her client then relayed that to specifically Andrea Jacobs. And they simply can't make that connection. There's too many pieces to go along there where they can't say that that ever happened. And Ms. Jacobs, they could have asked her, and in fact, I think they asked her, but she was here. You could ask her, did you know that Catherine Wells was attempting to, or had been contacted or anything like that? And that I don't believe is in evidence. So I don't think you can rebut something that is not in evidence, which is the whole point of this.
Right. Well, and I'll just stop you. I do agree, and I realize defense may read the Houston case differently than I, but I do agree with Mr. Overstreet on this. At least the part I agree with him is that Ms. Jacobs, I don't know if she was directly asked, did you learn about the fact that police were looking through information via Ms. Wells or by conversations that were occurring in the jail? But her testimony, regardless, was that she had not known anything about this until the detectives appeared to talk to her. So I'm not going to allow the testimony of Ms. Hersher, given, and I think I'm sort of tipping my hand a little bit, but given my thinking on proper rebuttal evidence with regards to bias, I'll tell defense at this point, I'm unlikely to allow the testimony of Aaron Jeffers, but defense will certainly be able to make a proffer as to Mr. Jeffers' testimony, and if it changes my mind in any way, well, so be it. But I'm just sort of scheduling-wise trying to tip people off a little. Go ahead, Ms. Maxfield.
Your Honor, in terms of proffers, just so that we don't make Ms. Hersher's life any more miserable than it needs to be, could we offer her prior testimony
Absolutely.
as a proffer, with the addition that what she would have added today is the time frame and the fact that she actually called me warning me that this was going to blow up in the jail. If we needed to, we could put an investigator on that after this call from Ms. Hersher. I instructed my investigators to get to the jail as quickly as possible to get all of our clients' pleadings and discovery and everything else, because Ms. Hersher, I think, accurately predicted that this was going to go like wildfire through that dorm.
So I guess the question to the state is whether or not, and maybe you'd need to talk to Ms. Hersher, I don't know, but whether or not the state is willing to stipulate that the conversation, and I know you have indicated, Mr. Overstreet, that Ms. Hersher contacted you, not that you contacted her, but that this contact was somewhere around the February time frame. If you would stipulate to that, I don't know if you would or not, and if you would stipulate that Ms. Hersher indicated or would indicate to Ms. Maxfield that, I want to make sure I say this right, Ms. Maxfield, that she had contacted you and said this is going to blow up like wild.
Well, no, I can read the court my phone memo from the conversation.
But she called you, right?
Yeah, she called me.
Okay.
Because her client was so upset.
Okay.
And she wanted to let me know that her client wouldn't be testifying, but that her client was, quote, a hothead who blew her top. Those are my quotes. And and warning me that this was likely to move through this dorm very quickly. And
okay.
I'm not going to put the word wildfire.
Sure, that's fine. That's fine. But to clear, I just want to make sure what we're talking about is simply a for the record proffer. I'm not allowing Ms. Hersher's testimony, but what she would have said, adding that to what she said during the motion, that's the proffer of what she would have said. So with those last two, so I am going to allow what she said previously to be the proffer of what she would say, because I've heard her say it. I just don't know about these two additional facts, and I don't know if the state does either. So what's your thoughts on that, Mr. Overstreet?
I can't recall the exact time without reviewing my phone records.
Sure.
So I don't feel comfortable just saying yes.
That's fine.
To the time frame.
Okay.
To the second part, I thought the testimony from Ms. Hersher, I could be wrong, but I thought it was that Ms. Maxfield reached out to her, and she was surprised by that because she hadn't heard from her in like a year.
Oh,
So I'm a little confused.
Well, maybe
Well,
we can put her on the witness
why don't,
stand.
we'll just put it on for those two
Sure.
limited points. That's fine. We can do that. I tend to think that's correct, but we'll see what she has to say. All right. Let me see if there was anything else. Then, the only other, the state had potential objections to Ms. Slavic's personal knowledge. So I suppose we'll do a very short, I would expect it to be very short, 104 hearing with Ms. Slavic before she testified with regards to just sort of ascertaining, when someone forms an opinion, it's a little hazy, right? You form an opinion in part based on your personal observations of someone, but also on what others have discussed with you. That's how people form opinions. But with regards to her having a sufficient basis to say she has an opinion of Miss Jacobs, and with regards to if she was going to testify, she's aware of her reputation. It's my understanding the state wants a 104 hearing to establish that.
I mean, I agree with Your Honor. I don't know that we're as concerned if she says, I know Miss Jacobs, and I know that she has a reputation for untruthfulness. I agree with Your Honor, because the reputation is, well, that's what other people think as well.
Well, opinion too, right? I mean, the reality is when we as humans form opinions, it's not entirely, it's a lot on our own personal observations, but there are other sources of input coming in too, right?
I agree with that. But I think that's where I would want to know the source of that information.
That's fine.
But to the reputation, I think that that's fair enough and probably
Okay.
is well within the scope.
All right, so we'll have a very brief 104 hearing with her, but just again, as a reminder, my parameters are that she can indicate, the time frame that she knew Miss Jacobs, the fact that Miss Jacobs stayed at the waterfront condo that she shared with her brother from time to time. Again, she can't get into the specific acts of deception, but we'll look at her personal knowledge with regards to these, or I guess I'm going to say more accurately, the foundation for either her opinion or knowledge of reputation. So should I tell the jury? Go ahead, Ms. Maxfield.
I've got Ryan Scott in my ear, and I don't want to let this drop.
Sure.
The other case that we asked the court to consider with respect to the right to present extrinsic evidence if a witness denies is Janes v.
Right.
Kane, which came out at the same time. And what Janes v. Kane says is that it's ineffective assistance of counsel not to pursue the potential benefits or the hope of benefits. And I think in this case, even the inference that there should have been a hope or there would have been a hope. And I think what Janes says is that a witness's potential bias is not limited to instances where the witness actually receives a tangible benefit in exchange for testimony. A witness can have bias resulting from the benefits that he or she hopes to have. So if that's my obligation to pursue that with witnesses, certainly it's material, and I think we would have an obligation to ask the court to allow an extrinsic evidence when the witness doesn't acknowledge that hope.
Right, and I think that our disagreement is on the scope of extrinsic evidence and how it relates to a particular bias. But yes, the record will reflect that I've also considered the Jane versus Kane case in reaching my decision. Now, when I bring the jury in, I guess my thought would be, so the first witness is Miss Maddox. You had some questions about how you might use documents with her. So what is it you're wondering about with regard to that?
Your Honor, there are a set of exhibits that we went through at the hearing, and my understanding is that the transcript of the detention hearing with Judge Acosta, that was certainly public record, and under the TUI authorization that she has, I think she would be allowed to speak to that. I don't know whether the court considers that specific acts. She's got the 2018 case, she's out on pretrial release, she meets Dr. Haney, starts working for him, and commits the new fraud. Both of those convictions clearly are things that she can testify to.
Sure.
But I'm a little unclear about whether she can refer to that detention hearing and,
Well, of course, I don't know what was said in the detention hearing, but I guess the parameters of my ruling are that you can talk to Ms. Maddox about her being the prosecutor on those cases, the period of time that the deceptive acts occurred. So, for example, 2011 to 2015 for the one case, and I think it was 2018 to 2020 for the second case. You can certainly ask her opinion as to Ms. Jacobs' credibility. You can bring out the fact that Ms. Jacobs was on release for the first case when the acts charged in the second case occurred. But as far as specific other things that, I'm not sure what other specific things were referenced in the hearing that you're describing, but generally specific acts of deception that she committed or things that she did that were additionally negative while she was out on release but aren't criminal convictions, those I wouldn't be allowing. So is there something specific that?
I think that answers the question, and I would just, as we had proposed with Ms. Hersher, ask that the full transcript of that earlier testimony be offered as a proffer, what we would like to elicit from her this time, in addition with those exhibits.
And has that already been marked? That
It has, but I'm just making it clear for the record that we would propose.
I'm just wondering which exhibit.
Oh,
was it?
it's, I'm sorry. The detention hearing transcript is 401. I misunderstood what you were asking.
Just look at that for me. No, that's all right. I just want to take I just want to remind myself what it looked like exactly. Oh, that's right. Yeah.
And then along those same lines, 402 is the government's sentencing memo. So that's
Sure.
more formalized, but I think similar in nature, description of sort of the scope of the conduct. And I think the court's ruling with respect to the plea agreement would also address those two, but we'd just like to make it clear that for purposes of proffering now, we're including all of those.
Yes, all of those will be included as part of the proffer.
Okay. And then there are some that we did not use with her earlier that I'm unclear about. What we have marked as 413 and 414 are the indictments in the two federal cases.
I haven't actually seen them. Do they get into the specific acts? Oh, we don't have them, I think.
I have a copy here. We have them electronically. I didn't forward that set because we're still redacting the photographs. And we are going to offer the photographs that Mr. Hersey went through yesterday, but because there were 202 and we're only offering 30, we're just getting that pared back.
Okay, sure. So I'll be honest with you. I'm not familiar with the form of federal indictments, and I don't know the extent they get into the specific acts or if there's a multitude of charges. I just don't know. So I guess the short answer is I'd have to see it.
Chris, do you want to sticker? No? Okay.
So this is your copy. That's why you didn't want to put a sticker on it, or?
Well, it is marked at the bottom there.
Oh,
See, and that,
I
what I was
see.
gonna do, this is the jury's set of exhibits, so I am going to forward these once we get 410 redacted, get the things that shouldn't be in here out of the notebook.
okay. So just so the record can reflect this, Exhibit 413 is a 12-page document that lays out the charges in the case. Well, the way it seems to be written is 3:18 CR 00427, and it does indicate just a plethora of factual allegations related to what would ultimately become a conviction that are connected with 15 counts. So I won't allow Exhibit 413 to be admitted. However, to the extent that you want to ask, because I think this, frankly, just, has the state even seen this?
I can't be sure, but I know what it is, and
Okay.
we of course object.
Sure. I would say it would be fair game with Ms. Maddox to indicate the number of charges, the names of the charges. The state can, of course, cross-examine on what she was actually convicted of. Go ahead.
Why would it be permitted that she could list off a bunch of charges that she may well actually be innocent of? Again, they're trying to ask the jury to conclude more wrongdoing than what she's actually been convicted of, which is the proper impeachment evidence. To say she was indicted for the charges that she had been convicted of, that seems fair. You were indicted for this charge, you pled guilty to that charge. I think that is fair and proper impeachment. But to go down a list of other charges that she's not been convicted of.
Yeah, I'm shifting my thinking on this. Yeah, I'll allow you to ask her what she was convicted of in the period of time for which the criminal conduct occurred, but not getting into these specific charges or the specific acts that are listed in the indictment.
All right, then I've got 4 more exhibits, and I think these are responsive to what the court.
Do you
has
want
just-
this back? Or?
Well, I do.
I'll just put it here. That's okay. I'll just set it there.
Oh, and then first what these are.
Okay.
I have to come back up anyway. So it's fine.
Yeah, I'll just set them here for now.
Okay. So 415 and 416 are the plea petitions, and respectively the 2018 and the 2020 case. 417 and 418 are the amended judgments in the 2018 and then the 2020 case.
Which one was the amended judgments?
The 417 and 418. So there are 2 plea petitions. And
Let's make sure this, has the state seen those?
Are they in the stack you gave
I
us the
think
other
so.
day? Then, sure.
Okay.
Yeah.
Well, let me start with the amended judgments. Is there any objection to the judgments?
Yes, Your Honor. The witness already acknowledged the convictions, and so I believe the proper objection is actually cumulative, and the problem with the actual judgments is there's a lot of other stuff in there that would need to be redacted,
Oh, I see. Yeah.
and so, but it is cumulative. She acknowledged her convictions.
So I would allow defense, and I'm looking at 417 and 418. I would allow a redacted version of this to be admitted. I will tell you, here's some of the issues that I see right now. It lists count numbers for the things that she pled guilty to, which of course would provide extraneous information about other counts that she was not convicted of. It also talks about various counts that are dismissed, which gives sort of the same information. So with 17 and 18, I would overrule the cumulative objection, but I would require redaction to eliminate the type of information which I've indicated I don't feel is appropriate.
The plea petition would typically have less of that information in it, so that may not need the same redaction. But that, of course, is a document that she herself has signed.
All right, is there an objection to the plea petition?
Yes, Your Honor. Again, it's cumulative, especially with the judgment. We know she entered a plea. She acknowledged that she entered a plea. Also, nobody asked her if that was her signature. And there's, I think, a lot of other information that would need to be redacted, similar to what Your Honor has already acknowledged.
All right, so I would be inclined to allow admission of these over the cumulative objection, but again, I do think there would be information in here that would need to be redacted specifically, and I'm just going through this quickly, but as I look at page 8, for each of the counts, it sort of lays out the specific acts that justify the plea for guilt. So that would need to be redacted. In the rest of it, I don't know if defense thinks is overly helpful or not, but I'll allow it to be. So I see also, so the problem is page 2 contains the same thing because it's laying out the elements of the charges.
But those are the counts of conviction, and that is her description of the conduct.
So I understand that, but normally when we allow evidence of prior convictions, it's the title of the conviction, if even that. Oftentimes defense objects even to the title of the conviction, but it's not a description of the elements or the actual conduct that has occurred. So if defense thinks this still has any value with redactions to page 2 that eliminate the specific elements but leave the name of the offense, and page 8, which includes factual assertions that support the convictions, then I would be inclined to allow it, but otherwise not.
All right, and then, Your Honor, I think you did rule on the plea.
Just 1 second,
Oh, I'm
sorry.
sorry.
Can I clarify which exhibit numbers we're referring to, because I just.
That was 415 and 416.
Allowing redacted admission of 415, 16, 17.
Yes,
Okay.
but of course, if there's going to be redactions made, the state can take a look and see if they have additional objections.
So 413 and 414, no. 415, 416, 417, and 418 only with redactions.
Yes, sorry, that goes there.
Thank you.
And then, Your Honor, the plea agreement, I believe you said, would not be admissible, but would be accepted for purposes of the proffer.
The plea agreement, which number are we talking about?
That's the one that you just reviewed that we talked about last evening. It
Are you
was-
talking
it's
about
403.
403?
Yes.
Yes, that's correct. You're right.
Okay, and then I can anticipate the court's ruling on these, but for purposes of the proffer, I think we'd like to put into the record 419, 420, 423, and 424, and those are her self-filed motion for early release, that compassionate release motion at the pro se stage, another petition that she filed for habeas corpus relief, which we had discussed a few days ago, a bankruptcy settlement agreement, and a bankruptcy complaint.
I'd have to look at those.
I can forward them, but I'm willing to accept in anticipation of the court's ruling.
Well, let me see them. Has the state seen them?
Don't know.
Probably.
Okay, let's
Should
have
be
the
in
state
that
look at them
stack.
first.
419. We don't have the habeas petition here. Okay, I'm gonna take back what I said about 420. That's not there, and those should all be in that stack from the other day. And for 420, we don't need it.
There's 420 if you want.
Let me take a look.
This is 419.
So I just have 419.
And then, Your Honor, I don't have 420, so I did not give it to you, and I'll just withdraw that. That was the habeas petition, the one about the tear gas.
But didn't you
and
say some other ones too?
I did, and the
I'm
state's
still
still
reviewing.
reviewing those.
Oh, I see. All right, does the state have an objection to 419?
Yes, Your Honor, that's her petition that's full of hearsay. It's also not relevant. It's cumulative to her own testimony. It's also just not impeachment. I don't know what they're impeaching. They didn't show her this document, so she didn't decline that it was hers. And she admitted that that's what she's doing. So
Well, so let me ask this, as far as sort of the state's authentication argument, what would the defense response be to that?
Well, as far as authentication, Your Honor, it's got the file stamp at the top from the federal court, does it not? That
It
came-
does, yes.
Okay. I think all of those are self-authenticating. They're clearly
All
public
right.
records.
I wasn't necessarily making an authentication argument, Your Honor. I think what I was attempting to say was that because it wasn't shown to her, she didn't say, "Oh, I didn't do that." That's not, you know what I mean?
Sure,
So
sure.
that's to the impeachment argument, would be, yes, I could see that document being offered if she declined that she had done that.
Sure.
Or denied that that was her document.
All right, I'm
Can I
gonna,
respond to that?
I'm gonna allow 419, and I'll explain why. She was asked, as she testified, repeatedly asked by Ms. Maxfield, I think, as to whether, as a result of, she acknowledged that she applied for compassionate release. And she was repeatedly asked if she hoped to get out of jail quicker as a result of that, and she repeatedly answered that she did not, that she essentially wanted to get her credits for, I forget what it was, but she talked about her credits that she wanted to get, not that she wanted to necessarily get out of jail. And yet on page 5, she indicates that she is requesting to be in the custody via home confinement through the CARES Act, which seems to me contradictory to what she testified to when she was on the stand. So I will allow 419.
Ms. Jacobs' petition?
Yeah.
Okay, it has a slightly different name on the.
And then I guess 420, or I don't know what the next one is, but it looks like the state has reviewed it. Ms. Weinmiller, if you want to bring it up to me to take a look at.
It's actually a motion, I'm sorry, it's not the settlement agreement, it's the motion proposing the settlement agreement.
You look like you have a question about
I
419.
figured the list of names don't quite match, but I think I figured it out.
Okay, all right. So just so the record's clear, I am now looking at 423, motion and notice of intent to settle and compromise adversary proceedings. So is this, just so I'm clear, which case is this in reference to?
There is a federal bankruptcy, and it is the business bankruptcy that she was questioned about, and there is a tie between that bankruptcy, that business, I believe, in the DOJ investigation, but separate and apart from that, the fraud, the underlying fraud conducted in the course and scope of those business activities in the course of the bankruptcy trustee felt that she had fraudulently transferred what I believe was just under $530,000 of assets. And the accusation, that allegation by the bankruptcy trustee, the federal bankruptcy trustee, was specific to Ms. Jacobs. So it's a business bankruptcy, but it wasn't like somebody else was thought to have committed that fraudulent transfer.
She was unaware of a bankruptcy investigation.
Right, and as far as the impeachment value, in addition to, in addition to that obvious consequence, she was a party, she was notified of all of these bankruptcy trust proceedings. She knows that the bankruptcy concluded. I mean, she must know that. She testified that she was unaware of these matters, but that's an example of this issue that we've been highlighting for a few days now, that some of her positions are just not credible. Even though she's in custody, it is just not plausible. She was allowed to participate in those bankruptcy proceedings, tracked all of that, was representing herself. And we just don't think that we should be forced to take at face value her denial that she was aware of that. It's
Does the state ever, how does the state respond to this one?
I don't believe her signature's on that document. I can't recall, Your Honor.
It's not.
So I don't know how we can infer that she knew about it. She said she wasn't aware of it. She wasn't aware of any investigation into her regarding the bankruptcy. And I don't know if Your Honor remembers, if you were looking at her, she actually did seem genuinely surprised when confronted with it, and asked her for some clarification. But regardless of that, all this defense is doing is saying, well, she just must have. This is not extrinsic evidence to prove that she knew. If her signature was on it, I think that might be a different story. If there's some sort of documentation that showed that she was an active participant in it, that would be a different story. That's not what they're presenting to the court. And I think that that goes along with this next document. I think it's 424. I have other objections to this, but I think it's...
All right, why don't I see 424? I'm not going to allow 423, but it is part of the proffer.
And Your Honor, I respect the court's ruling. I'm not asking you to revisit that. I would just point out the obvious, which is that I don't think you can settle any case, including a bankruptcy, without the parties agreeing to a settlement.
The document, can I see that one more time, please?
424.
No, 423.
Oh, sorry, 423, yes.
All right. I'm going to stay with my ruling. I do understand the defense position. 424 is a 47-page document. Which is the complaint. So the complaint itself is actually only about 3 pages, 4 pages, and then it has an attachment, it looks like, which is the 47-page document, which is laying out the various alleged fraudulent transfers. So in other words, the specific acts. So I'm not going to allow 424, but it will be part of the record for the proffer.
So on 423 and 424, that would be
Correct. Correct.
And then, Your Honor, for purposes of
And here's this.
trial, I don't know that we've discussed 400 being admitted. That's the DOJ letter from John saying it was admitted, of course, for the purposes of the hearing last Friday. She was questioned about that, acknowledged receiving it, denied having read it carefully. But I think that would form, the basis of the understanding that she knew that there was that pending serious prosecution. And
Okay. State's position.
Once again, Your Honor, she acknowledged it, so it would be cumulative, and I understand your previous rulings regarding cumulative evidence, but I just nonetheless wanted to make the record. But also, there are details of what is alleged to have happened.
Right.
And so, once again, it's the same.
So here's what would be my position on this. It's sort of a mixed bag. I would allow admission with some heavy redaction. Specifically, what I had given parameters for the questioning was that the investigation occurred between 2017 to 2019, and I also indicated that defense could ask about the sum dollar amount. There's a lot of other information in here regarding the specific acts, regarding just details generally that I did not permit questioning on. Now, there was a question asked about the number of Medicaid recipients. There was no objection. I would have sustained an objection. But basically, the bulk of this letter, which is paragraph 2, I would allow the portion where it says, in summary, we are writing to him. Do you have a copy of it, Ms. Weinmiller?
I have it almost memorized.
Okay.
I don't though.
So the first sentence, in summary, we're writing to inform Ms. Jacobs that we're nearing a completion of a criminal investigation of Ms. Jacobs. Then I would require redaction all the way up to from approximately 2017 to 2019. Then I would require redaction until the point where it says received approximately $234,900 from Medicaid, and then the rest of that paragraph would be blacked out. But as far as the first paragraph, it seems fine. And I think the third paragraph is fine too. And I don't know if you had a chance, I don't know if you have it in
Yeah,
front of you
we do.
too. Okay.
I don't have it in front of me, but I understand.
So I'm overruling the cumulative objection, but sustaining it to the extent that a large portion of it's outside the scope of what I allowed.
All right, my very last question has to do with the photographs yesterday. That's 410. When we have that pared back to just the photographs that were displayed, will that be admitted?
I don't, is there an objection to that?
I don't understand the relevance of them, but
Well, I understand the relevance of them. Yes, I'll allow admission of the photographs.
Your Honor, I guess I would expand that just a little bit.
Sure.
And just that they showed a bunch of different dorms. The only way those could possibly be relevant is if it was where the conversation actually took place. And that testimony was not elicited. They're showing medical dorms, which I think certainly was not one of the dorms that they were together in. And then they showed a series of other dorms without any foundation being laid as to where this conversation actually took place. They are laid out differently. And so had there been some evidence of that, I think that I would probably withdraw my objection, but there simply isn't any.
Let me ask about the medical dorm. I know that Mr. Hersey testified she was in that dorm. She never did, or we never heard anything much about a medical dorm. What's your position on those photographs?
Well, Your Honor, let me start by saying the conversation did not take place, and so we can't pin down exactly when or where it occurred.
Oh, I see.
When Ms. Jacobs was asked about it, all she could say is that it happened at Inverness. And
I know,
don't-
I agree, I agree.
And so what we did is find out where our client was housed and take photographs of those
I see,
dorms,
I
because
see.
it had to be in a dorm where she was housed, if it ever happened.
Okay. You don't need to say anything more. I'll allow omission of the photographs. I realize there's no concrete evidence about where Ms. Jacobs said the conversation occurred, but frankly, with the exception of the medical dorm, they all looked exceedingly similar. And as far as where the phone is located relative to other people who might be coming in and out, it's also exceedingly similar. So I'll allow admission of the photographs, and state can argue about what they mean or don't mean.
Sure.
Well,
Once I cleaned it up.
limited to certain photographs that were, so it's not 410 in its entirety, which I think is 200 photographs. It's going to be whatever was shown in court, and I know that they still have to label that or rework the exhibit. But to the extent the exhibit is reworked, if we want to call it all by 410 and just pare down and let the state see that it is the photographs that were shown in court, then it'll be admitted.
Thank you. And we do have those labeled, so that won't take long. We'll just have to pull out the pages.
So what I propose to tell the jury is that we're first going to take testimony from one witness, and then I'm going to just tell them the day's going to be a little bit of fits and starts, that we are going to have to take a few breaks, but that we hope, tell me if I'm wrong, we hope that we will be able to get through the remainder of the witnesses today, and that on Monday we'll be able to give them instruction and go into closing arguments. And, this case, the instructions are much shorter than many because there's only one charge. So I don't know if we'll get to them today or not, but I would think we could probably get through them in a half hour. So I guess what I'm thinking is we'll see where we are at the end of the day. If we haven't had a chance to get to them yet, I'll tell the jury to come back at 9:30 on Monday, but we'll come earlier, hash out what the instructions are, and then go into closing.
Sounds good.
But, all right.
Was Ms. Hersher's testimony going to take place in front of the jury or?
No, absolutely not. No, it's gonna be a proffer. Is Miss Hersher here?
She's in the hall.
I mean, maybe we should just take her proffer right now since it's just those 2
We'll find
points.
out.
Let's just make sure she knows.
Ms. Hersher is here in the hall.
Okay.
Yes, I'm gonna read you guys the ones that are not being admitted exhibits, and they will just be considered part of the proffer, and then you all can keep part of it. No. Yes, I'm gonna make a big all caps note that I didn't.
Not, might have gone to the restroom or something. We can wait a minute just to see. I mean, it just makes sense if we can,
Mr. Jeffers here?
Ms. Hersher was here.
yeah, she might have gone to the bathroom.
Yeah, no, I'm just
I
letting
think
you know.
he
How
just
was the
mentioned
record until then?
taking relations.
Yeah, let's go off. And if we haven't located her, oh, she's there, I think, okay.
Pardon? That's the only witness you have for the jury this morning? is
Right,
Maddox?
exactly.
I have extras, I heard.
Oh, she needed a mask, is that?
Okay,
all right.
Oh, this morning.
You have good hearing.
Howard.
We can,
Hear it from back there.
all right.
Yeah, I have it somewhere, I forgot. So we have 2 witnesses for the jury this morning.
Thank you so much.
Well, so I hear everyone sort of whispering, does it make sense then if there are 2 witnesses who are actually available to just take them one after the other and then do the proffer of Mr. Jeffers or not? I'm flexible, I'm just asking what makes sense.
I think we have 2 proffer, is Hersher being allowed to say anything? No.
Who?
He's gonna let us proffer, but she won't testify in front
Right.
of the jury.
So we
Right.
have 2 proffer-only witnesses, and then Donna Maddox, who's a jury witness. She's also contending with a death in the family, so I'd prefer not to have her wait all morning. But
Yeah, I agree.
the next witness that would be a jury witness would be Mr. Howard on WebEx, and that wouldn't be at least for an hour.
Got it. Okay. And Ms. Hersher is here now or not? She's not here. Okay. Do we know if she has stepped into a restroom or do we have any idea where she is? I guess is what I'm asking.
Let me go check the restroom, but
No, I don't want to yank her out of a restroom. I'm just trying to figure out whether it makes sense to. I just am trying to figure out the logistics of what we should do next. If we think she's going to be back in the next 5 minutes, we'll take a break. We'll have her proffer because I think that's going to be very quick, and then we'll take Miss Maddox. Do we think she'll be back in about 5 minutes?
Yes.
Okay, then let's just take a break for 5 minutes, and we'll take Miss Hersher first.
Okay, we'll go off record and we'll use the WebEx.
please be seated. And is Miss Hersher present? She is, I see her. Come on up, Miss Hersher. We'll have her take the stand and then raise her hand for an oath.
Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yep.
Okay, then you may be seated, and you may remove your mask if you'd
Actually,
like.
we'll let you leave it on.
Okay.
And then if you could please state and spell your name for the record.
Alicia Hersher, can't even speak, ALICIAHERCHER.
All right, and Ms. Hersher, I'm sure you already know, but just in case you don't, I have excluded your testimony for purposes of the trial, but defense would like to make a proffer with regards to two particular points, so whenever defense is ready.
Good morning, Ms. Hersher, and welcome back. I'm sure you're excited to be here.
Thrilled.
You and I had a conversation back in 2021 regarding your client. Is that right? Who was housed with Ms. Brophy at Inverness Jail?
Catherine Wells?
Mhm.
I don't remember exactly when it happened, but you have some documentation of it, so it was a year and a half ago is all I recall. But we did, yes.
Does 2021 sound right?
It does, yeah.
The year?
Yeah.
Okay. And I've shared with you my file memo regarding the conversation.
Yeah, you did send me that.
Okay, and that's dated February 21st of 2021.
Yep.
And maybe 2 weeks before that date or a few weeks before that date, had you had a conversation with Mr. Overstreet?
It was well before that date because the reason you called me was because Miss Wells had gotten very upset. So it was, I'm embarrassed that I don't have file notes. It wasn't important to me, but it was before that. It was a few weeks. It could have been a month. It could have been a couple weeks. After I talked to Catherine Wells, and she got upset, you called me and I called you back, yes.
Okay, so it's your memory that I called you.
Yes,
You didn't call me. And that I had.
I called you back, but you called me, which
That's
surprised
fair.
me,
No, that's
yes.
fair. No quarrel. And I called you because your client was upset. Is that right?
Yes, my understanding,
What you remember?
right, from both you and Ms. Wells was that she was very upset, that I had even suggested that she might consider, if she wanted to, or if she had information, testify against or debrief about Ms. Brophy, who was her friend. Yes, she was very upset. And you wanted to know what was going on with that.
Okay, so something had already blown up. Is that right?
Oh, yeah,
Okay,
yep.
all right. So something had blown up. Does this time frame sound right? Around February 21st of 2021?
It was more than a year ago. It was less than 2 years ago.
Okay,
So I believe
that's the
you.
best you can do.
I did, by the way, in anticipation of this as of last night, I looked at Ms. Wells' case in OECI to remind myself when things were happening with her case, because that would be create a benchmark. She did a plea mid-January of 21. She was sentenced in this court in March 8th of 2021.
Okay,
So it is believable to me that this happened in between that,
within
yes.
that time frame.
Yes.
Okay. Now, just for our record, so that we don't have to cobble the two together, can you relay again the conversation that you had with the prosecutor regarding potential cooperation of your client, whatever you can remember?
So the way I recall it, and as I mentioned before, I don't have notes, but my recollection, Mr. Overstreet and I were talking about some cases we had together. I recall it as a casual conversation, and I recall it as being in a hallway, but whatever. It wasn't on the phone that I recall. It was in person, but we were in the hall talking. And her name came up. As I said before, I'm chatty. It might have come up because I brought it up, but I don't know why. Ms. Wells had been looking for, should I just do this narrative or do you want me to stop and let you? Okay. Ms. Wells had been looking for opportunities to reduce any sentence she had. She was in on a serious case. Her name came up, and
I don't know if I knew at the time, I don't think I did, but it came up that Mr. Overstreet, at that point, it was clear, I don't remember if I said that or Mr. Overstreet did, but that she was in custody near Ms. Brophy. And he asked me, well, do you think she might want, if she's looking for a deal, do you think she might want to, if she had information, talk to us about if Ms. Brophy had made any admissions? This is a standard thing, it was a big deal. And so something that, again, thinking back over this, I do recall now that Ms. Wells had mentioned to me that she was friends with Ms. Brophy, and the reason this, since we've talked about it, at some point I probably knew that they were together because she had mentioned a writer friend she was in custody with, and she said, we're writing a book together about Ms. Wells' experiences in her life, and it's been varied, right? So I did know they were friends, but I didn't actually know, no offense, Ms. Brophy's name. I'm not good with names, and I don't have a dog in that fight. I, just knew that she had a friend. So, which explains possibly why I waited a week or two when I talked to her on the phone at the jail, to say to her, as your attorney, I know you're looking for deals and ways to improve your situation. If you had information about this admissions, that's something you could testify about. She became enraged. Why would I ever suggest it? I said, all I'm saying is I have a duty to let you know that that's something, since you're looking for deals, that could possibly improve your situation. She was furious. She was furious, yelling at me. And I said, okay. Close that page, close that book. We're done with that. That was the end of that. I'm rambling, sorry. So my discussion with Mr. Overstreet, as I recall it, absolutely honestly, to my recollection, was he said, if she happened to have it, let me know. Okay?
Fair enough.
Okay? Anything else?
No. And then this call that you received from me came a few weeks after that. Does that seem right?
Yeah, it took some time, and apparently, again, that's not something I know about, but you indicated that you were aware that she was upset.
I don't have anything further. Thank you.
Yeah, cross-examination.
The only question I have, Ms. Hersher, is in conversations with your client, did she bring up the name Andrea Jacobs?
Never heard it.
Nothing further.
Okay. Any redirect based on that one question?
No.
Okay. You can step down, Ms.
Okay.
Hersher. Thank you.
Thank you. Am I done?
You are, I believe you're
You're
done.
so done. Thank you.
Thank you.
All right. So are we ready for the jury and Ms. Maddox?
I think so.
All right. And I know we let the jury go get some coffee, so we'll see if they're back.
They were told to be back by 10:25. It's 10:26.
Okay, perfect. Okay.
Okay, after we go off record, and I'll get the jury.
Yes.
Okay. Go off record and meet for WebEx.
Seated. I wanted to tell the jury, as I did yesterday, that we are coming to the end, and inevitably in a trial, when you get to the end, there are times that we have to take up matters outside the jury's presence. But just to give you an idea, we currently anticipate that the final witnesses will be put on today. At the very worst, it could spill over slightly into Monday morning, but I doubt it. I think on Monday you'll be getting the instructions and the closing arguments, and then deliberations will begin. So just wanted to give you an idea. So with that, I will turn to defense and ask if their next witness is ready.
Yes, Your Honor. The defense calls Donna Maddox.
All right, Ms. Maddox, if you would please come up and just step on into the witness box.
Your Honor.
Okay, I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to provide in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, then you may be seated and you may remove your mask. And because we're being recorded, I'll ask you to please state and spell your first and last name.
Name is Donna Maddox, Donna Maddux.
All right, and Ms. Maddox, I think you know, but there is water there if you want any, and then when defense is ready.
Thank you, Your Honor. Morning, Ms. Maddox. How are you employed?
I am a partner at the law firm Lewis Brisbois. I practice data privacy and cybersecurity law.
And were you formerly in the U.S. Attorney's Office?
Yes, I was a federal fraud prosecutor from 2012 until 2020, so about 8 years.
All right. And in your time in the U.S. Attorney's Office, did you have other assignments besides fraud cases?
I was assigned to the fraud unit, so every case I did touched something related to fraud, embezzlement, tax crimes, or elder financial crimes.
All right. In your capacity as an assistant U.S. attorney, did you get to know a woman named Andrea Jacobs?
Yes, I did.
And what was the capacity in which you met her?
I was assigned to investigate some allegations of criminal conduct related to claims of embezzlement.
And without specifying all of the incidents that you were investigating, did you end up prosecuting her?
Yes, on 2 matters.
All right. I'm going to hand you 4 exhibits. Defense 415, 416, 417, and 418. Not put together, but they do have tabs. If you would you identify for the record what the case numbers were of the cases in which you prosecuted Ms. Jacobs?
Yes, so looking at Exhibit 415, the first case number was case 18. 18 denotes the year it was filed, 2018, CR 427. That case was assigned to Judge Hernandez. The second matter was 20, CR 177, also assigned to Judge Hernandez.
Okay, and does the 20 signify then that that was year 2020?
Correct.
All right.
That it was filed.
Did you prosecute both of those?
I did.
Were those matters ultimately resolved with convictions?
Yes.
Okay, and how did those convictions come about? Was that a trial or was that a plea?
There was a joint plea as to both matters with a consolidated sentence for both.
All right. Now, without specifying anything about other counts, what were the counts for which she was actually convicted in each of those 2 cases?
Do you want to know the count number or just the actual?
Not the count number, just the name of the crime. What was she actually convicted of, first of all, in the 2018 case?
So the counts of conviction are listed in Exhibit 417 for the 18 matter. Those counts are filing a false personal income tax return, false impersonation of an employee of the United States, here the IRS, and aggravated identity theft.
All right, was there also a conviction in the 2020 case?
There was.
And what was that conviction for?
The count of conviction in the 2020 case,
Counts, we're just talking about the name of the conviction.
the name of the conviction is bank fraud.
Bank fraud? All right. All right, and in the 2018 case, was Ms. Jacobs originally out on federal pretrial supervision?
Yes.
Did the facts, well, could you tell us, how did the 2020 case arise? And with respect to that federal pretrial supervision? I don't want you to talk about the investigation in detail, but did those facts, well, let me back up just a little bit more. What years, without talking about what the specific conduct was that led to that first case, the 2018 case, what years did that conduct span? What was that indictment actually addressing, just in terms of time frame?
So the time frame alleged for conduct in the first indictment spanned from January of 2011 through December of 2015.
All right. And then with respect to the second case, when you're addressing the relevant conduct that led to that indictment, what were the dates during which that conduct occurred, was alleged to have occurred?
Do you have the plea agreement?
I do.
I would need to reference the plea agreement to be certain. Yes. Just 1 second. In here, it references the 2020 charges specific only to 2019 conduct.
All right. Now, would that conduct have occurred after the 2018 case had been lodged against her,
Yes,
and after she had been arraigned?
correct, on the 2018 case.
So was she on federal pretrial supervision at the time this 2020 conduct occurred in 2019?
Yes, so after arrest on the first indictment, she was not detained. She was released under federal supervision.
All right. You received permission from the U.S. Department of Justice to testify here today?
That was required.
And the limitation that's placed on that is that you must refrain from commenting on anything that's outside the public record. Is that correct?
I'll allow that.
Yes, only items that are already in the public record.
Okay. So keeping that limitation in mind, did you have occasion to form an opinion as to Ms. Jacobs' truthfulness during the course of your work?
As I stated on the record during one of her release hearings, I had found her, based on this record and my experience with her, to be consistently untruthful.
Thank you. I have no further questions.
Any cross-examination?
No.
All right. May Ms. Maddox be excused?
Yes, Your Honor. Thank you.
All right, thank you, Ms. Maddox.
Thank you, Your Honor.
All right, and then correct me if I'm wrong, but I believe we need to take up a matter before the next witness, is that correct?
I'm confused. Are we talking about the proffer, Your Honor?
Yes.
Yes.
Because I don't think there's another witness quite ready before that, right?
Oh, we have a witness who's on WebEx.
Then
that we could-
let's do
yeah.
that,
Yeah.
let's do that.
Your Honor, may I approach you between the exhibits?
Yes, of course. And then who is the defense's next witness?
Michael Howard.
Okay.
Can you set it up for me?
Sure, sure. Take your time.
This is the court clerk, Mr. Howard. We have you on, but you're muted. Could you go ahead and unmute yourself and turn your video on, please? Mr. Howard, if you could please turn on your video and unmute your microphone. Mr. Howard, this is the court clerk. I have unmuted you. If you could please turn on your video or respond to confirm that you can hear me.
Can you hear me?
Yes, we can hear you now. Great. Could you go ahead
Oh,
and
okay.
turn on your video for me, please?
I don't have any buttons that says turn on the video.
Are you on a computer?
Yes.
Okay, on the WebEx window at the bottom, there is a series of circles with images in them, and one of them looks like a camera, so it has a box with another little box to the right of it, and it will be red with a line through it, and if you hover over it, it will say start my video.
I don't have any of those boxes on the bottom of my screen.
Are you on a Mac or a PC?
A Mac.
Try pressing Command-Shift-V.
Command-Shift-Z.
V as in Victor.
Oh, sorry. Command-Shift-V. And nothing's happening.
Well, we may need to take a break.
If we just go off the record for a second, Judge,
You think if you talk to him?
I think I can talk through it, and I don't think we need to dislodge anybody, but I don't think it needs to be on the record.
All right, let's go
Okay.
off the record. Mr. Howard, we're going to try to talk you through this, so hold on just a moment.
Okay, thank you.
Okay, we are off the record. Mr. Howard, is the WebEx screen taking up your full computer?
Yes.
Okay, so the full screen?
Yes.
Press the escape button,
Escape. Where's?
ESC.
Okay.
And that should make
Yes.
the window smaller. And now at the bottom, you should see an option at the bottom bar that will have an option.
Right hand, Mr. Howard. My clerk will give you an oath.
Okay. Okay, Mr. Howard, under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can go ahead and put your right hand down. And because we are being recorded, I'll ask you to please state and spell your first and last name.
Michael Howard, Michael Howard.
And before we begin, Mr. Howard, it sounded like when you were trying to get your computer working, there was someone else present with you giving some suggestions. I don't know if it's your wife or who it was, but we will need you to be completely alone for your testimony. So if there is anybody else in the room, we'll need them to go to another room.
She just left, Your Honor. It is my wife.
All right, perfect. Then when defense is ready.
Thank you. Good morning, Mr. Howard.
Good morning.
You're in Hawaii?
That's correct.
We're interfering with your Hawaiian vacation, is that right?
Well, it is a little bit.
Okay. I wonder if you can just tell generally the jury what you do for a living.
I'm a forensic scientist, and I originally started with the Oregon State Police, and that was in 1975.
Okay. And how long did you work with the Oregon State Police?
I worked with the Oregon State Police until I retired in 1999, and then I started my own consulting business about forensics.
Okay. And what's your expertise?
Well, when I first started, we were generalists, and now I mostly do things like firearms, blood spatter, and crime scene reconstruction.
Okay. And were you retained by the defense in this case to both consult and do some testing for us?
I was.
Are you generally aware, just from your training at the state crime lab, that sometimes the trajectory of a bullet can help a party reconstruct the distance between the shooter and the victim?
I'm aware of that.
Okay. Is that something that you did as part of your work for OSP?
Yes.
Okay. In 2020, were we working with you to try to reconstruct the distance between the shooter and the victim in this case?
We were. I don't recall exact dates, but I did work with you on that.
Okay. And did we ask you to do an analysis of Daniel Brophy's T-shirt to determine what it could tell us about the shooter's distance from Mr. Brophy?
You did ask me to do that, yes.
Okay. And were you able to do it?
Well, I performed the test, but it didn't tell us the distance.
Okay. After you tried to do that test, did the defense file a written pretrial motion based on the loss of gunshot residue?
I'm going to sustain too. This is for limited purpose, Ms. Maxfield.
Did the defense, related to the testing that you attempted, did the defense file pretrial motions with the court that were going to be heard at a hearing?
Okay, hold on that, Mr. Howard. I'm going to sustain the objection if you want to ask the witness about timeframes of consultation and relating to the distance. I'll allow that.
I'm more focused, Your Honor, on the date that the hearing was scheduled.
If you want to talk about the date of a hearing he may have attended, that's fine.
Okay. Did you attend pretrial hearings at pretrial motions in this case?
I attended one via this WebEx, and I don't recall when that was.
Okay. If I told you that there were hearings in mid-November of 2020, and again, due to the COVID delays, in May of 2021, would that sound familiar to you?
Well, I know the one that I attended via WebEx, there was snow on the ground, so that could easily be the November one. I don't recall anything about a spring one.
Did you testify at the spring one? Do you recall testifying under oath?
I don't.
Okay. All right, but you do know that what you were able to do or not able to do was at issue in those hearings regarding
Yes.
determining the distance between the shooter and the victim.
Yes, I know there was discussions and hearings about that, but I really at this point don't remember all the hearings.
Okay, but you're in Hawaii and you don't have your file, is that right?
That's correct. I do not have my file.
Okay. I have no other questions. Thank you, Mr. Howard.
Any cross-examination?
No.
All right, thank you for your time, Mr. Howard. You can disconnect.
Thank you. Am I excused, Your Honor?
You are.
Okay, thank you.
All right, and then for the jury, there is something that we will now need to take up outside your presence. I'm honestly not sure whether or not we'll have you back in before lunch. So we'll probably have you go back to the jury room for about 10 or 15 minutes and see where we are, but it's possible we will be sending you to lunch early. No, I think that's all right. And let me just ask defense before, Mr. Jeffers, you can come on up. We'll have you step into the witness box, but yeah, we'll get you sworn in and then I have a question for defense. But why don't you step into the witness box, get as close as you can to the microphone, but stay standing and my clerk will give you an oath.
Please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, then you may be seated. And then Judge, would you like him to keep his mask on?
We'll hold on for just one sec. I just want to ask defense before we start with Mr. Jeffers' proffer. Realistically, is there any way we get through Mr. Jeffers' proffer and call another witness before lunch? Is there another witness even available?
Your Honor, probably not.
Okay.
Because the new witness, the urologist, is ill, we did not ask him to hold indefinitely. We
Sure.
asked him to sign on at 1:10, and I think it'd be difficult to get him to make that adjustment quickly.
Oh, that's fine. He would be the next defense witness.
That was our plan, and we would have three more. So it would be the Patrick McCarthy, the urologist, Rhonda Slavic, who is WebEx, and then Curtis Haney, who's the dentist who testified
Yes.
previously from.
And
River.
they've all been scheduled for the afternoon.
Yes.
Okay, yeah, I'm asking the question because what I'd like to do is let the jury go to lunch early so they're not just sitting around in the back room. So we'll go off the record for a moment and we'll have Ms. Lou let them know they can do that and to be back at 1:30.
While we're still on the record for this, I did not have Mr. Jeffers
I
put
know.
his name on. Do you
I
want
know.
to do that now or?
Nope.
Okay, we'll
We'll
go
do it
off
when you get
record
back, yeah,
and I'll mute for WebEx.
yeah.
We are back on the record, Judge.
All right, we're back on the record. So, Mr. Jeffers, if you can state your full name and spell both the first and last name.
It's David Aaron Jeffers. First name is David. Last name is Jeffers.
All right, when defense is ready.
Thank you. Good morning, Mr. Jeffers.
Good morning.
You're a lawyer.
I am.
How long have you been a lawyer?
It'll be 11 years in October.
And what kind of work do you do?
I'm a public defender.
Are you, well, let me ask you this. Are you certified to take the most serious of public defense cases?
I'm certified by the Office of Public Defense Services to be lead counsel in murder cases. The only thing I can't do is capital murder cases.
Where are you employed?
The public defender of Marion County.
And what is your role there?
I'm the deputy director.
And in your role as deputy director, what are your tasks or what kinds of things do you do?
So I'm supposed to split my time between trying very serious cases and supervising our attorneys. And supervising 14 attorneys who range in qualification from misdemeanor to co-counsel in murder cases. And
Are you responsible for their continuing education?
I am. I'm responsible for their quality of work and their continuing education, and I do it at least once a week with a group on Fridays, and then many other times individually and in other organized ways throughout the year.
So is it your job to teach the attorneys in your office how to understand and apply Oregon's repeat property offender law?
That is part of my responsibility, is to make sure that they understand and can apply the repeat property offense statutes. And I feel a lot of, and give advice about that when they have questions.
It's a confusing statute.
It can be. There's a lot of different potential outcomes usually.
And did we ask you to analyze a set of facts, hypothetical facts, that we thought were at issue in this case?
Yes.
Let me ask you now, assume that a hypothetical client bills Medicaid for multiple CPAP machines to individual recipients. Assume that there are 139 Medicaid recipients billed for 2 or more CPAPs in a 2-year period.
Okay.
Assume that there's a 5-year warranty on each CPAP. First of all, let me ask you, just hearing that part, and assume that there is a loss or total receipt from Medicaid by the defendant was $234,900.
Okay.
Just knowing those facts, how many potential instances of criminal conduct would that be?
So if there's individual potential victims, there could be a crime and even multiple crimes for each one. So for all 139, there could be criminal liability.
So there could be a potential of 139 counts.
Yes, and potentially one also for the government, but at least for the individual.
And what would those potential offenses be?
So when I look at that, I see potentially theft, identity theft, and filing fraudulent health claims.
Are these crimes to which this repeat property offender law would apply?
The first two are. So if they were theft, either it would have to be at least theft in the first degree for the repeat property offense statute to apply. But identity theft, yes, the repeat property offense statute would apply if they have the right predicate offenses.
And so if we just assume by dividing 139 into $234,900, would that indicate that that the loss in each count would be somewhere around $1,600?
If that's the assumption, I think it's without more information about the timing of those, whether they were individual or bulk. It's hard for me to say what the individual amount would be.
Okay.
But for identity theft, it doesn't matter what the value is.
All right. So what would be the simplest way for a prosecutor to charge this case?
In my opinion, the simplest way would be 139 counts of identity theft.
So can you then tell the jury how those 139 counts of identity theft, how would the repeat property offender statute apply to those?
So if you have a prior predicate offense, it depends on what your prior criminal history is at the time. And so if the person has no prior criminal history, before you get to the mandatory repeat property offense sentence, there have to be 4 predicate offenses.
Just for clarity of the record, I don't mean to interrupt, but I just want the record to be clear. The jury is not present right now. So I think Ms. Maxfield was asking if they were present and if he was allowed to testify what he could tell them, but I just want to make it clear the jury's not here.
Yes. So you said there need to be 4 predicate offenses?
4 predicate offenses, yes.
What would qualify as an eligible predicate offense?
Identity theft.
Would federal convictions, assuming that this isn't a person with no prior criminal record, would federal convictions for identity theft or bank fraud, would they qualify?
I didn't look at bank fraud. I looked at federal identity theft. That might qualify, just plain identity theft. The aggravated identity theft in the federal statute I think is harder to get to apply. And the problem is that the statute allows for federal crimes that are equivalents of Oregon convictions to count as predicate offenses, but the rules are fairly exacting about what constitutes a equivalent conviction in Oregon. So if the elements are different enough from what you would get in Oregon and they don't match what you would get in Oregon, then they would not apply.
Okay, so let's assume that our hypothetical client is the clean one owner with no prior convictions. Can you describe how the repeat property offender statute applied to 139 counts of identity theft would play out or could play out potentially?
So because each person has a separate identity, they could be separate incidents. And the first 4 would be predicate offenses. And then after that, each one, in the first 4, they would still be eligible for probation, likely.
How does it come to be that the first 4 would be predicate offenses if they're all charged for the first time in one indictment?
So under the 137.717, ORS, Oregon Revised Statute 137.717, it has a specific definition for what constitutes a prior conviction. Prior convictions under that statute are when they are pronounced in court and not part of the same criminal episode. And so a good defense attorney would probably argue that some of these are part of the same criminal episode, but there is the potential for each individual victim to defeat that argument and for it to be separately or consecutively sentenced. And so each one can become a predicate for the next one that comes after it, right? And so once you get past 4, then you are at 13 months of prison becomes the
5th conviction becomes?
The 13 months of prison. Yeah, you go from probation to a term of imprisonment, and the statute orders that the judge shall impose that sentence. There is also a potential for downward departures in some circumstances and stipulation of the parties. With 139 individual victims, I think a downward departure would be unlikely in this.
What happens with the 6th count?
So for all but one offense, you tack on an additional 2 months. However, the statute actually leaves out identity theft from the list of offenses that tack on 2 months. So that's the only one where it doesn't add an additional 2 months to each one. So it would remain 13 throughout, but you could have 135 13-month prison sentences that could be consecutive.
So it goes 13 plus 13 plus 13.
Yes.
And it could be consecutive.
Yes, that's a very lengthy property sentence. I calculate that at 146 years. And, you know, I don't know that a judge would impose that kind of property sentence, but
But
that's
legally, that's what's,
just from standard charging, that's the exposure.
what if instead of the prosecutor aggregated the counts?
That
How
would be,
might that look?
that would be more of a better case for the defendant if the prosecution chose to aggregate. The statute allows for aggregation of 10 or more offenses within a 180-day period. And so I don't know if we said the time frame. Did we say the time frame that these, in this hypothetical?
That letter, I think it's 2017 to 2019, but.
So if we assume 2 years, then there's 4 potential, the largest groupings they could do would be 4 aggravated identity theft. So the 4 180-day periods over 2 years. And if they just put all of the potential crimes into that 180 days for each one, if there were at least 10 that occurred over that period of time in each quadrant, they could get aggravated identity theft times 4. So 4 separate charges of aggravated identity theft.
Okay. It's been a long time since I've had a property crime in state court, but there's something about the 200% rule and the
Right.
400% rule. How does this play into this?
In terms of property, the repeat property offense statute, they do not apply. There's a case directly on point that says that the 200% rule and the shift to I rule do not apply to property offenses. So what does that mean? It means outside the context of property offenses, there are some limitations under the sentencing guidelines on what the maximum sentence can be. And in those circumstances, sometimes the maximum sentence cannot exceed 200% of the initial sentence that the person would receive. And then under the shift to I rule, the judge might be required to, at a certain point, start moving to I on the grid block. And if you're not familiar with the grid block, I is the lowest level of criminal history. There's a crime seriousness scale that Oregon uses where there's a grid, and on one side is crime seriousness, and it goes from a low of 1 to a high of 11. And there's also a criminal history scale that goes from a low of I to a high of A. And so where those two meet, depending on the crime seriousness and the person's criminal history, you have a grid block that's the presumptive grid block for the offense. And so that would come into play on the first few charges in this case, when we're just talking before you get to the maximum, the predicates you need to make it a full sentence. But the court, the Oregon Court of Appeals has said that that sentencing scheme, the grid block, that scoring and the shift to I and the 200% rule just don't apply to ORS 137-717. So the reality is there's no cap on what the maximum total sentence can be. So in this context, it could be the entire 146 years.
So in terms of the exposure that our hypothetical client has under these facts, what that person's charged with is pretty much left up to the discretion of the prosecutor?
Yeah, the prosecutor does have the discretion on how to charge it, and they could make it, lesser, or they could make it extreme.
So they can slice and dice it based on how they view the criminal defendant?
Whatever thought process goes into how they decide to charge it, including the defendant and maybe their past or things like that.
So I think as you analyze this, you're talking about what was the best case scenario? Was it 26 years?
So not the best case scenario would be 6 years. And so the way that would work is if they did split it into the 4 aggravated identity theft categories and they didn't have any prior offenses, the first one would not be a predicate offense. But when you're talking about aggravated identity theft instead of just plain identity theft, it only takes 1 prior aggravated identity theft. So if that aggravated identity theft went first, then the second one would carry a presumptive 24-month prison sentence. And then it would go, then, and so would the next two. So you would have probably a probationary sentence on the first one, unless there was some kind of departure right from the beginning based on criminal history, and then 24 months, 24 months, and 24 months. So if they were consecutive, they could be 6 years, and that would be really the best case scenario.
Okay, but if the prosecutor decides to just, completely go crazy, what's the worst possible outcome?
So the very worst possible outcome, in my opinion, would be if the prior federal conviction was a predicate. So if it was an aggravated identity theft predicate, although I think that's probably unlikely given the differences between the statutes, but if the state tried to charge it that way and was successful then the very first, literally all 139 offenses could be aggravated identity theft. And I have to check and see again what I thought that would be. Yeah, if all 139 are aggravated identity theft, and that's because there's part of Oregon statute says that it's aggravated identity theft if you have a prior conviction for aggravated identity theft, right? If all 139 were aggravated identity theft, it would be a maximum of 278 years.
Which, honestly, that's not gonna happen.
There was probably, I think there would be some serious constitutional problems with a sentence of that length for a property offense, but it does show the potential power of prosecutorial ability to charge some very serious crimes there.
And again, a defense attorney's job would be to explain how this could potentially roll out depending on how the case was indicted.
Yes, this is all information that if I represented hypothetical client, I would be relaying to them.
Okay, all right. Do I have anything else? Oh, can you just talk generally about whether sometimes defendants within the state court system receive benefits or things of value in exchange for their cooperation?
I have represented clients in the past that have received benefits for cooperation.
The federal system is although prosecutors have a lot of discretion, there are a lot of rules that kind of guide that process. Are there rules that guide the process within state courts?
I mean, I don't know what rules apply to that. I know that if there's a specific deal that's in place, then that's something that the defense should know about. But in my experience, they tend to say things like, if they cooperate, we can be helpful to their case or something like that.
So usually those things are stated in very vague terms.
I have yet to have a specific offer be made for a specific agreement in advance.
So the way it's typically played out is first there's cooperation, and then somewhere down the road, without it ever being spelled out, there's a benefit that follows?
That is what happened in my cases.
Okay, 100% of the time?
I mean, when they cooperated, yes.
And are you generally familiar with how that's played out within your office?
It doesn't happen all that often. And I don't know if I know it. I can't comment specifically about what's happened in other people's experience. All I can say is what's mine.
All right. I have no further questions. Thank you.
Cross-examination?
Yes, thank you, Ronna. On the topic of cooperation agreements, when you said you actually haven't had a formal cooperation agreement?
Not in the cases where they were seeking my client's cooperation, no.
Okay. I just want to make sure, because maybe it's done differently in our county as opposed to yours, but when the initial cooperation is brought up, does that not begin with a proffer?
And one of these, I can't remember if this was in Marion County or Deschutes County. I think I may have had one in Marion County and one in Deschutes, but I don't recall there being a formal letter of anything.
So the government asked you for cooperation of your client.
Yes.
Your client gave it without any promises?
In one instance, I remember my client was actually unhappy with what ended up happening, but
Well, did you understand my question? Or
I believe so, yes.
so your client just gave their cooperation without any deal?
Without a firm, there is, as far as my recollection, I've never received a written formal offer from the state about what's going to happen.
I understand the written form offer. I'm saying, did
Yeah.
a prosecutor come to you and say, if your client
Yeah.
cooperates, we'll agree to X, Y, or Z?
I don't recall that happening, no.
Are you familiar with how the DOJ, Oregon Department of Justice, how they handle cooperation agreements?
I'm not, because I work for Public Defender of Marion County, so I work for the circuit court level offenses. So the DAs I work with are the Marion County District Attorney's Office.
Okay, no familiarity with DOJ then?
No, there may have been maybe one time in my career that a DOJ attorney was standing in for one thing or another, but that didn't involve a cooperation agreement.
Okay. And do you know somebody by the name of Andrea Jacobs?
Do I know her personally?
Yes.
No. I mean, I know of her.
Based on this case?
Yes.
Okay. So when defense counsel retained you to help them out on this case, did you do any it sounds like you did some calculations based on a hypothetical.
Yes.
Did you reduce that to writing at all?
I took some notes about it because there's math involved and it's complicated, so I want to remember what my thoughts were about it.
Right. Did you provide that then to Andrea Jacobs?
To Andrea Jacobs? No, directly.
Okay. I don't have any other questions.
Any redirect?
No, Your Honor.
All right, thanks, Mr. Jeffers.
Thank you,
And
Your Honor.
I can just, so Mr. Jeffers isn't sitting out in the hallway and wondering, I am going to stick by my earlier ruling and not allow his testimony in the case, but he has made his proffer, so other than that, is he excused?
Thank you. Thank you, Mr. Jeffers.
Thank you.
And correct me if I'm wrong, but that's all we really have, right? So, go ahead.
Yes, Your Honor, I have been intending to ask the court to take as part of the record, in light of the ruling that this Exhibit 212, the text thread between Nancy Brophy and Dan Brophy would not be admitted, just to accept this notebook and exhibit
Sure.
as part of the record.
Absolutely.
It's much easier to review than the other version.
No, I think that's probably the easiest way to do it.
So it's marked as an exhibit, but it's not.
It's
accepted as an
not admitted for purpose of the trial, but it's being offered and admitted as a proffer. It's just to complete the record, so if there's ever an argument.
I just want to make sure I understand and get the other things that were admitted, that weren't admitted, but were accepted for part of the proffer, and make sure that I understand how to get those to the file room. But I just am trying to make sure I understand.
Sure.
And with respect to the others, if it would be helpful, we can separate those into a separate notebook, so if they're just part of the proffer, they won't be mixed in with the jury exhibits.
That'd probably be very
That
helpful.
would be great.
Okay,
Yeah.
we'll do that.
And let me ask the sides then, since we do have a little bit of downtime, I'm not going to force this if there are other things you'd prefer to work on right now, but we could work on the instructions now.
Yes.
Defense?
Ms. Maxfield has been very good about reading things that I have not had time to get to.
Sure.
I have not actually read through the combined draft yet.
Nor
I was
have
going
I.
to do that
That's
over the
fine.
lunch hour.
We don't have to do it right now. It's fine. All right. So let's then, we'll have a lengthier lunch than normal. We'll be back at 1:30 unless there's anything else we can do right now.
Just a proposal, Your Honor, because we have so much time, could we come back at 1 and do jury
I
instruction?
can't because I have I have a lunch appointment.
Okay.
That's the problem. Otherwise, it'd be a great suggestion. But I think we've already excused the jury till 1:32. Go ahead, Ms. Wendell.
Ms. Liu, I just wanted to say, we do have the two WebEx witnesses from this afternoon calling in at 1:10, and
Yes,
be
to
happy to
sort
try
of
to
set that
get
up
that,
ahead
yes.
of time.
Exactly.
I will be here at 1:10 to work with Mr. Stringer on that. So.
Good, thank you.
All right.
Okay, so we will go off record and we'll be in recess until this afternoon. All right?
All right.